Dear learner on the platform of MOOCs, I am Professor Muhammad Nafis Ahmad Ansari from Department of Political Science of Aligarh Muslim University. Today's lecture we are going to go through the administrative tribunals. The term tribunal is derived from the word tribunes, which means magistrates of the classic Roman Republic. Tribunals are intended to relieve high courts and supreme courts for the heavy burden of case and provide an expert values for the delivery. The term tribunal is derived from the word tribunes, which means magistrates of the classical Roman Republic. Tribunals are intended to relieve high courts and supreme courts of the heavy burden of cases and provides an expert venue for justified delivery. Tribunals do not follow the same judicial hierarchy as normal court. Initially, the terms court and tribunal were used interchangeable and had the same meaning. However, as the legal system evolved, the purpose of these documents shifted. The term tribunal referred to the adjudicatory organizations established by the state with judicial and quasi-judicial responsibilities as supported by precedent from the Supreme Court. The tribunals follow the status that establishes them. Unlike regular courts, they do not have inherent powers unless expressly stated in the statute governing them. Traditional laws do not constrain them and instead rely on natural justice principles to resolve disputes. Evolution. Throughout the 20th century, one notable development has been the expansion of administrative tribunals in both industrialized and developing nations. In India, tribunals covering various topics including banking, taxation, trade, industry, and so forth, having occasionally been stabilized at the federal and state level. Tribunals are intended to provide an expert forum, relieve the High Court and Supreme Court of a substantial burden of cases. The government of India has been debating the issue of creating tribunals, administrative tribunals, for a long time to give government workers quick and affordable remedies regarding complaints about recruitment and other terms of service. The discontented among the staff members, regardless of their class, categories, or affiliations, stem directly from instances that are either improperly handled or have been neglected for an extended period of time. The establishment of an organization was necessary to assist in the providing harassed workers with timely redress when they feel their service issues are not being handled fairly and that they are being treated unfairly. Employee morale would be rise rise and employee morale would rise and motivations would improve as a result increasing productions. Civil services tribunals were to serve as the last resort for the government orders, imposing severe penalties such as dismissal, removal from the service, and rank reductions. The recommendation came from the Administrative Reform Commission 1966 to 77, a committee chaired by the J.S. Shah has suggested as early as 1969 that an independent tribunal be established to handle service disputes only, giving, given the numerous writs petitions that employees has filed regarding these issues. When addressing a number of writ petitions in 1980, the Supreme Court observed that the public employees should not be pressured to spend their time and energy on courtroom disputes. It is recommended that the civil services tribunals be established as the ultimate arbiter for settling disputes about the terms and conditions of service. To ensure effective administration, the government recommended that public employees first approach fact finding administrative tribunals. The topic was also discussed in the old other venues, and it was agreed upon that in the public interest, the creation of civil service tribunal would be desirable and required to hear the complaints and grievances of government employees. The Indian Constitution was modified to allow for establishment of civil service tribunals through the 42nd Amendment, Article 323, Clause A. The Act gave the Parliament the authority to establish procedures for the arbitration or trial disputes and complaints by administrative tribunal regarding the appointment and terms of service of individual appointment into public service and posts in relation to the union's affairs, those of any state, local government, or other authority operating within the borders of India, as well as those under the control of government or any corporation that government owns or controls. The Administrative Tribunal Bill was presented in the Lok Sabha on January 29, 1985 and was ratified by the President of India on February 27, 1985 in accordance with Article 323A of the Constitution. Administrative Tribunal Act 1985. The Administrative Tribunal Act of 1985 was established by the Parliament with the spirit of Article 323A contained in the preamble, as previously noted, and based on the aforementioned provisions of Article 323A Clause 1. Specific provisions pertaining to the administrative tribunal's establishment, jurisdiction, powers, process, etc. are covered by the Administrative Tribunal Act of 1985. The corresponding subclauses under the Clause 2 of the Article 323A of the Indian Constitution give power to these Act provisions. Administrative Tribunals Act 1985 establishes a central administrative tribunal, state administrative tribunals for each state, example Haryana Administrative Tribunal, and joint administrative tribunals for multiple states. The Central Administrative Tribunals was created on November 1, 1985 with a main bench in Delhi and additional benches in Allahabad, Bombay, Calcutta and Madras. The Central Administrative Tribunal is responsible for resolving disputes and complaints related to the recruitment and service matters for all India service members, civil servants and defense personnel including civilians. The objective of the establishment of Central Administrative Tribunal CAT. The objective and reasons for establishment of CAT as evident from the enabling provisions of Article 323A, the provisions of Administrative Tribunal Act 1985 are: number 1, to reduce burden on regular courts. CAT aims to give faster justice than traditional courts, which face challenges such as overcrowded cases, a system of appeals, and complicated procedure laws that were avoided. to provide simplicity of procedure for disposal of cases being bound by only the principles of natural justice, to provide an expert forum with a judicial and administrative member with specialized knowledge and skills in the topic, to provide cheaper justice. Jurisdiction and powers and authority. Section 4 of CAT Act of 1985. Section 4 of the Administrative Tribunal Act of 1985 addresses the establishment of administrative tribunals. Section 4, Clause 1 establishes CAT through a notification from the central government to exercise the jurisdiction, powers, and authority provided by under the Act. This section is directly derived from the Article 323A, Clause 2, Clause A of the Indian Constitution. Section 14 of the Administrative Tribunal Act 1985 outlines the tribunal's jurisdictions and powers. In accordance with the Section 23 and 17 of the Contempt of Court Act 1978 and 1985, the CAT established the Contempt of Court CAT Rules 1920, 1999, 1999 to govern its proceeding under the Act. These are in a place to implement Article 323A, Clause 2, Subclause B of the Indian Constitution. Contempt allows the tribunal to execute its orders and verdicts and penalize those who violate them. Administrative tribunals have the authority to issue the writs. The tribunal follows the principles of natural justice while deciding on cases. The Act states that a tribunal shall not be bound by the procedures laid down in the Code of Civil Procedure 1908, but shall be guided by the principles of natural justice. These principles ensures that the CAT remains adaptable in its approach. Applicants only need to pay a fee of rupees 50. The applicant might present a person or through a lawyer. Previously, only Supreme Court could hear appeals against CAT orders, not the higher courts. In the Chandra Kumar case 1997, the Supreme Court ruled that the restrictions on the High Court's jurisdiction is unconstitutional, as judicial review is a part of Constitution essential framework. The tribunal has the same jurisdiction, powers, and authority as the High Court to punish contempt of itself. The provisions of Contempt of Court Act 1971 are applicable. This assists the tribunals in ensuring that the decisions are taken seriously and not dismissed. Composition of administrative tribunals. Each tribunal shall consist of a chairman, a vice chairman, a judicial administrative members. Initially, the CAT comprised a chairman, vice chairman, and members. Later in 2006, the Administrative Tribunal Amendment Act abolished the provision for vice chairman. As a result, the CAT now lacks a vice chairman. In 2019, the chairman's sanctioned strength is 1, while the member's sanctioned strength is 65. The president appoints individuals from both judicial and administrative backgrounds. They serve for 5 years or until they reach the age of 65 for the chairman and 62 for the members, whichever comes first. Qualification for appointment. To be appointed as a chairman or vice chairman, candidate must be a judge of High Court or a secretary to the Government of India for at least 2 years and have equal experience either under the central or state government. To become a judicial member, one must have a judge of an high court or have held a grade 1 position in the Indian legal service for at least 3 years. To be eligible for appointment as an administrative member, candidate must have held the position of additional secretary to the government of India or an equivalent pay under central or state government for at least 2 years, or joint secretary to the government of India or equivalent post under central or the state government for at least 3 years. They must have adequate administrative experience. Appointments. President appoints the chairman, vice chairman and members of the central administrative tribunals. For the state or joint administrative tribunals, the president consults with the governors of the respective states. Appointment of the chairman, vice chairman, or judicial member requires consultations with the Chief Justice of India first. In the chairman resignations, dies, or is unable to perform their duty due to illness or other reasons, the vice chairman will fill the vacancy until the chairman resumes their duties. Terms and office. The chairman, vice chairman, or other member shall hold office for a term of 5 years from the date on which he enters his office or until he attains the age of 65 in the case of chairman or vice chairman, 62 in the case of any other member, whichever is earlier. Removal and resignation. Chairman or vice chairman or any member of the administrative tribunals may resign by submitting a written notice to the president. However, they will continue to hold the office until 3 months from the receipt of the notice, the expiry of their terms of office, or the date of joining by the successor, whichever is earlier. To be removed from the office, the president must issue an order based on the proven misbehavior or incapacity following inquiry by Supreme Court judge and a fair hearing of the complaints. The chairman of the Central Administrative Tribunal shall be ineligible for further employment under either the central government or state government. Still, the vice chairman of the Central Tribunal will be eligible for the chairman of diet or any state tribunal or vice chairman of any state or joint tribunal. The chairman of a state or the joint tribunals can be appointed as a member of the central tribunal or as the chairman of another state or joint tribunals. The vice chairman of a state or joint tribunal may be the chairman or vice chairman of a central tribunal or any other state or joint tribunal. A member of a tribunal can be appointed as its chairman or vice chairman or as a member of another tribunal. Salaries and allowances are other terms and conditions of service. 5 include all retirement benefits in respect of the chairman, vice chairman, and the members of tribunals will be such as prescribed by the central government and cannot be varied to their disadvantage after appointment. Administrative tribunals for other matters. Under Article 323b, the Parliament and the state legislature are authorized to provide for an establishment of tribunals for the adjudication of disputes relating to some matters. For example, taxation, foreign exchange, import and export, industrial and labor, land reforms, ceiling on urban property, election to the parliament and state legislature, foodstuffs, or rent and tenancy rights. Article 323A and 323B differ in the following 3 aspects. While Article 323A contemplates the establishment of tribunals for public service matters only, Article 323B contemplates the establishment of tribunals for certain other matters mentioned above. While tribunals under 323A can be established only by the Parliament, tribunals under 323B can be established both by the Parliament and the state legislatures with respect to matters falling within their legislative competence. Under Article 323A, only one tribunal from the center and one for each state or two or more states may be established. There is no question of a hiring of tribunals, whereas under Article 323B, a hierarchy of tribunals may be created. There is no question of an hierarchy of tribunals, whereas under Article 323B, a hierarchy of tribunals may be created. Limitations: administrative tribunals may make arbitrary and inconsistent decisions as they do not follow uniform precedents. Administrative tribunals lack a structure limiting judicial scrutiny of a services matters. The tribunal's administrative and technical leaders may not have legal or judicial experience. Administrative tribunals now have the power to issue writs previously reserved for the Supreme Courts under the Constitution. The current administrative tribunals lack adequate structural functional analysis. This is the presence of an appeal forum with the tribunal, which causes a significant inconvenience. For instance, if a bench of the tribunal issues a decision, it applies throughout the country as there is only one central administrative tribunal for India, with multiple benches stationed around the country. An appeals option for unsatisfactory judgments inside the tribunal system would provide justice for both government employees and the government. Recent issues are there. Recently, the Supreme Court of India challenged the government to prevent evidence demonstrating its reason for implementing the Tribunal Reform Bill of 2021. Issues raised by Supreme Court: repeated violation of Supreme Court order. The center is not following the repeated directions issued by the court to ensure the proper functioning of the tribunals. The provisions in the ordinance regarding conditions of service, tenure of the tribunal members, and the chairmen were struck down by the Supreme Court. Security of the tenure. The Tribunal Reform Act 2021 prohibits appointments to tribunals for people under age of 50 years. It diminishes the durations and security of tenure, undermines the separation of power. The measures permits the central government to judge the selection committee's recommendations, preferably within 3 months of receipt. It violates the concept of separation power and judicial independence, determinantal to the decision making process. These cases will be forwarded to the high courts or commercial civil courts right away. The absence of specialization in conventional courts may damage the decision making process. For example, the Film Certificate Appellate Tribunal FCAT heard only appeals against the censor board judgments requiring art and cinema knowledge. Furthermore, the dissolution of various tribunals and appellate bodies and the transfer of their powers to the High Court can be questioned because Indian courts are already overwhelmed with the current case load. Concluding this tribunal chapter, the Administrative Tribunal Act of 1985 established the Administrative Tribunal, a specialized judicial forum comprised of individuals with legal and administrative competence and experience. Like other courts, the tribunal aims to provide efficient and cost effective justice by eliminating technical procedures and reducing the burden on normal courts. It lacks inherent powers. Civil courts have a broad power beyond peripheral control, including judicial review of executive and legislative actions. The number of administrative tribunal is always on the rise. The system has proven useful and effective. It not only gives relief to the ordinary courts, but it also ensures prompt and cost effective justice for public officials. In issue issues affecting their service. Administrative tribunals offer advantages over traditional court of law, including lower cost, accessibility, independence, and technicalities, greater flexibilities, expected case resolution, and expertise in certain fields. Despite their benefits, two key obstacles hinders their effectiveness. Tribunals lack the impartiality and detachment of judicial officers, making it difficult to prove adequate review of administrative actions. Thus, it is critical to establish a judicial umbrella over the tribunals to assist protect the quality of justice. Administrative tribunals require additional judicial characteristics. Simultaneously, low court should be sympathetic and comprehend and administrative aspects to eliminate unpleasant qualities. Their way forward. The judiciary stands out for its impartiality, independence, fairness, and reasonableness in decision making. Parliament should use prudence with overturning or alternative court decision orders. Rapid justice delivery system that reflects the implicit guarantee of the right to people and personal liberty guaranteed by the Article 21, Part 3 of the Indian Constitution. New policy framework as well as the government and judicial initiatives are urgently required. Most tribunals demonstrate enormous potential in the past. Government should enhance them by delegating greater authority and resolving concerns such as a lack of funding, personnel, and infrastructure. Thank you.